Good morning, this is your Kelso Report for Thursday, November 17th, and I'm your host, Clark Kelso. Well, the news of the day is that the NBA's players have decided to disband their union and file antitrust lawsuits against the NBA league, asserting that the lockout threatened by the owners constitutes an illegal group boycott in violation of Section 1 of the Sherman Act. Although the players' complaints have not yet made it onto the web, so we can't view exactly what they are alleging, the reports are that the players may seek damages as high as $6 billion. Now, of course, the Sherman Act authorizes treble damages for antitrust violations, so the claim apparently would be that players would make approximately $2 billion during the season, and the lockout illegally prevents the players from earning those salaries. These are, of course, big numbers, whether it's 2 or 6 billion. And the players have secured the services of top antitrust lawyer and litigator David Boies. David is great, not only in court, but before the media. He is a fantastic performer. So no doubt the mainstream press will see this as a big move by the players and a serious threat to the owners. But a moment's serious reflection suggests that the player's position is not very strong, at least from a legal perspective. Boies most recently represented the NFL, which was itself sued by their players who unsuccessfully sought an injunction against the NFL's lockout, in circumstances remarkably similar to what the NBA and Players Union is going through. That case was Brady versus NFL, decided by the 8th Circuit just earlier this year. So Boies knows what he is actually up against. The problem is not with the basic strategy of disbanding the union and then turning to the antitrust laws. So long as the players had a union engaged in collective bargaining negotiations, it would not have been possible to use the antitrust laws at all. The whole purpose of collective bargaining is to engage in joint collective bargaining leading to joint agreements. And these are often agreements that otherwise would constitute restraints of trade. So collective bargaining is generally exempt from antitrust scrutiny. That's why you disband the union, to get rid of that antitrust exemption. But the problem for the players is that, as the NFL players found out earlier this year in their antitrust lawsuit, even though the players have disbanded their union, that does not mean the federal courts can immediately provide some type of quick relief that breaks the negotiation logjam. In the NFL case, the 8th Circuit held that the Norris-LaGuardia Act's anti-injunction provision still prohibited the federal courts from enjoining the NFL lockout, since the court found the lockout and lawsuit was still part and parcel of an ongoing labor dispute. What this means to the NBA players is that they don't have a very strong legal position to seek preliminary injunctive relief to block the lockout. The 9th Circuit might, of course, come out differently, but the 8th Circuit's reasoning is pretty convincing. I think that's probably why David Boies emphasized in his comments to the press today the importance and likelihood of a prompt settlement. As he noted, quote, "I think it is in everybody's interest to try to resolve this promptly. The longer it goes on, the greater the damages that the teams will face, the greater the damages that the plaintiffs will suffer, the players will suffer, and perhaps most important of all, the longer basketball fans will be deprived of basketball. So we hope that this will move quickly," close quote. Well, this is the Boies' equivalent of a public invitation to engage immediately in settlement talks. And with Boies at the table and presumably leading the players in the negotiation, I think there's a pretty good chance that a deal will be struck. The lawsuit presents enough of a threat in the long term for the owners to change their position slightly. And Boies knows that he needs to get to a settlement quickly to save what remains of the current season. If he loses the current season, the incentive to negotiate to a deal quickly will evaporate, and the parties will find themselves in a protracted, and from the public's perspective, utterly pointless lawsuit among billionaires. So Boies has extended the invitation, and the ball is now back in the owner's court, where they need to make a decision quickly whether to negotiate to settlement or sit it out for the long haul. And now our one-liners for the day. First, a death penalty case. The 9th Circuit in Rhodes versus Reinke affirmed the district court's denial of the petitioner's emergency motion for a stay of execution. The basis for the motion was that Idaho's use of a three-drug lethal injection protocol would not prevent the petitioner from suffering severe pain during the administration of the drugs. The Ninth Circuit rejected the argument, concluding that the three-drug protocol was consistent with methods of execution very recently approved by the United States Supreme Court in Bays v. Rees, a 2008 case, and by the Ninth Circuit in Dickens v. Brewer just earlier this year. So the court rejected that stay of execution. Next, in an environmental law case in Rock Creek Alliance versus the U.S. Fish and Wildlife, the Ninth Circuit rejected a challenge to the Fish and Wildlife's determination that construction and operation of a copper and silver mine in northwest Montana on land managed by the U.S. Forest Service would result in, quote, no adverse modification, close quote, to critical bull trout habitat and would result in no jeopardy to the local grizzly bear population. Both the trout and grizzly bears are on the endangered species list. The challenge was grounded entirely in factual arguments that Fish and Wildlife's analysis and methodology was inadequate and flawed. In these circumstances, the court could reverse only on a finding that the agency's decision was arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law. The court found that Fish and Wildlife correctly focused its attention on the various issues involved and treated each issue in its decision with care. In these circumstances, the court was unwilling to second-guess the expert judgment of the agency on the details of the methodology or analysis. Next, an employment law case involving sexual harassment in Fuentes v. AutoZone. The Second District rejected a challenge to a pro-plaintiff judgment in a sexual harassment case where the only basis for reversing the judgment was the defendant's claim that the testimony regarding the harassing incidents was, quote, inherently improbable, close quote. The appellate court examined the record and found that while there were conflicting versions of events and questions about witness credibility, those conflicts and questions are exactly the sort of factual matters for resolution by the trier of fact. Moreover, it is precisely on these factual questions that an appellate court should defer to the jury or other fact finder, since the appellate court is in a poor position to assess credibility or conflicting evidence. The court affirmed the judgment on liability as well as the plaintiff's request for attorney's fees. Finally, we have a Ninth Circuit in-bank order. In Veterans versus Shinseki, the court granted in-bank. Now, back in May of this year, a split panel of the Ninth Circuit, with Judge Reinhardt authoring the majority opinion, held in Veterans for Common Sense versus Shinseki that a federal court could exercise broad equitable powers to compel the Veterans Administration to undertake structural reforms to improve the quality of mental health care provided by the VA. Chief Judge Kaczynski dissented on the ground that Congress had clearly provided only limited federal court review of VA decisions, and that the majority had improperly hijacked the VA's mental health program. I predicted at the time that the case would go in bank or would show up on the Supreme Court's docket, given its focus on the extent of court power over federal programs, a fundamental jurisdictional question. Well, the Ninth Circuit has followed the first course of action by voting to take the case in bank. Argument will be held next year. I would not expect a decision until very late next year or even early in 2013. This will be a complex opinion, and we can be sure there will be both majority and dissenting opinions on the in-bank. Well, that's it for today's Kelso Report. Have a great day in the law.